Donald Trump tried to send migrants from Myanmar, Laos, and Vietnam to South Sudan against their will. A federal judge stopped him, and now Donald Trump is on the attack. Quote, the judges are absolutely out of control. They're hurting our country, and they know nothing about our particular situations or what they're doing, and this must change immediately. Hopefully, the Supreme Court of the United States will put an end to the quagmire that has been caused by the radical left. Joining us now, managing editor once again at The Bulwark and MSNBC contributor Sam Stein. Susan Glasser is still with us. All right, Sam, sending these migrants to a third country against their will, it's never been attempted before, but Donald Trump is trying to justify this by claiming that these migrants are criminals, they're the worst of the worst, but we, again, haven't seen evidence of this. If they are the worst of the worst, why are we not seeing that evidence? Why would they not want to put that out there?
Hey everyone, Dr. John here. Welcome. So what just happened, guys? A federal judge looked directly at Trump and stated with brutal clarity that he had knowingly and deliberately violated court orders on 9 separate, documented occasions. Not once, not twice, 9 times. The judge didn't hide behind legal jargon. He dismantled Trump's entire legal strategy in open court.
That's a great question. In this case, I think 2 things are happening. One is they did this already, obviously, with El Salvador, and there's been ample reporting that shows that they sent people who were actually innocent or not guilty of a crime, people who they were not supposed to send to El Salvador. And it's obviously created the quagmire that Donald Trump is complaining about right now. And I think in this case, what they've done is something a little bit more cynical, which is they've taken some fairly, clear-cut cases where there are deportation orders, and they've basically sent them to Sudan against the court order in order to create a political predicate that they can then use to hammer against the judges. But in the end, it's the same issue. And this is it's funny that Trump...
And demanded his team justify a pattern of defiance so consistent and so deliberate that the consequences being discussed weren't just legal penalties. They were personal liberty. This is the stuff of high-stakes drama that you'd expect to see on a streaming series. But it's happening live in the federal court system. We are witnessing a sitting political titan getting branded with a contempt ruling for consciously breaking direct judicial instructions. This isn't a parking ticket.
Blames this quagmire on the judges because it's a quagmire of his own creation. He is defying judicial orders. He is not obeying orders that he observed minimum due process and habeas corpus rights that the Supreme Court has already put in place. And he's trying to test the boundaries of what the legal system will allow. And so for him to blame it on anyone but himself is erroneous, frankly.
I listened to Susan, J.D. Vance talking to Russ Douthat, his long interview at the New York Times, and they talked a lot about immigration. And Vance says that this is an administration that inherited a historic influx of migrants from the Biden administration, which is true. The crossings were higher than they'd ever been, at least in modern times. And that it's just not possible for them to go down the regular routes of order to get these migrants out of the country, and that they ran on mass deportations. They held up the sign at the RNC, everybody cheered. They ran on this. So they believe they have a mandate, he argues, from the American public to make their best efforts to get as many migrants out of the country, undocumented immigrants, as possible.
This isn't a procedural snafu where 2 sides have a reasonable disagreement over the interpretation of a complex statute. This is a judge staring at a defendant and saying, I gave you a clear line, you saw the line, you understood the consequences, and you stepped over it repeatedly. That is the textbook definition of contempt. That is a stain on the fabric of legal accountability.
Yeah, Yale Law School is weeping right now with that argument, Katie. J.D. Vance knows much better than you or I do that is complete bunk, to be honest. That, in this country, we have a rule of law, and it doesn't have a little asterisk that says, except if you got a really big, historic, absolutely ginormous mandate, and then you don't have to follow the law. So let's dispense with that, because I think that Sam's point is the relevant point here. The administration is following a very clear-cut and purposeful strategy of setting up a series of legal tests by pushing the boundaries of what is possible and waging a number of court fights in which they are holding their options open to flout the judge's ruling if they do not believe.
And let's be absolutely crystal clear here. This is a federal crime we are discussing. Contempt of court is not a slap on the wrist floating in the ether of civil disputes. It carries the very real potential for incarceration. If this judge wakes up tomorrow and decides that enough is truly enough, the mechanism to put someone in a cell is already cocked and loaded.
That they have the means or the will or the political need to follow through on it. And I think that's why this is such a risky situation for those of us who are following with great anxiety, essentially, the Trump administration's attack on the legal foundations of this country. I think that the attack, we know where it's being mounted, and it's right here in terms of deporting immigrants to this country, to third countries, without any process, without any transparency, and without regard for what the law says.
There's also an interesting racial component to this, Sam, and there's always been a racial component to this. You can go back to Donald Trump making his first announcement for president in 2015, talking about Mexicans coming over the border and the way he described them. And then there was the announcement of a Muslim ban, talking about S-hole countries and only wanting immigration from Norwegian countries. I mean, there's a racial element to this, and that Donald Trump has capitalized, and that's what we're seeing again with the deportation flights to third countries, while at the same time, and stopping the refugee program, while at the same time allowing in 49 white Afrikaners. That racial element is...
But the truly mind-bending layer of this story isn't just the legal jeopardy, it's the staggering theater of the absurd irony that saturates every single frame of this narrative. We are talking about a president who constructed his entire political coliseum on a foundation of law and order. He branded himself as the sheriff. He chanted about locking up rivals.
Sure. No doubt. It used to be that you would do this stuff as a dog whistle, but this is a bullhorn. They're not like hiding the ball, right? The campaign, it was centered around Haitian migrants eating dogs, allegedly. Of course, that never actually was proved. It never became a thing. And they just moved on from it. But, in terms of the Afrikaners that they've sent here, I mean... We had a story up a couple of weeks ago on the Bulwark that just showed the hypocrisy here, which is they've gone around, obviously, on these college campuses, and they're sort of policing the visa system and saying, look, if you're publishing op-eds that are, sympathetic to Hamas or critical of Israel, you don't have a right to be here. We don't want people in our country on student visas, who are espousing views that are antithetical to what we think is in U.S. national interest. Well, it turns out that one of the 49 Afrikaners that they let in had a fairly extensive social media history where it was blatant anti-Semitism. And obviously that didn't matter to the administration because they let him in very specialized, unique circumstances. And so I do think...
He sold millions of hats promising to restore respect for the badge and the gavel. And now the script has flipped so dramatically that he's the one sitting at the defendant's table, being dressed down by a judge for breaking the very laws he swore an oath to uphold. The irony is so thick, so palpable, that you could cut it with a chainsaw. Let's pull back the curtain and walk through the meticulously constructed chain of events that led us to this explosive breaking point. Because the context here transforms this from a simple news brief into a 5-alarm fire for the Constitution. At the center of this judicial earthquake is an active federal case, and presiding over it is Judge Merchant, a figure who has just become a household name for anyone who cares about the separation of powers. This isn't a rookie judge. This is someone who understands the weight of the bench. Within the framework of this litigation, the judge issued explicit, written, and verbally affirmed court orders. These aren't loose guidelines or friendly suggestions scribbled on a legal pad during a coffee break. These are mandatory directives regarding the safeguarding of sensitive evidence, the strict timelines for discovery production, and the rigid architecture of how this legal battle is supposed to grind forward. The judge put up a fence and said, operate within these boundaries. Do not cross this line. Yet, Trump's legal apparatus decided, for reasons that will be scrutinized for decades, to treat these boundaries like chalk on a rainy sidewalk. Not once, not twice. We are looking at a staggering tapestry of 9 separate, identifiable instances where the defense team or the defendant himself failed the compliance test. 9 times, the clock struck midnight on a deadline or a procedure was ignored. The judge noticed. He connected the dots. He saw a toxic pattern of willful blindness that rendered the discovery process a mockery. And at that moment, the judicial tolerance meter hit 0. The judge essentially slammed the emergency brake on the proceedings and said, "This courtroom is now a courtroom of accountability. You will stand before me, you will articulate a defense for these violations, and you will convince me why I should not unleash the full punitive fury of the federal judiciary upon you." This is the ultimate stress test for the American experiment. It demonstrates in real time that the Oval Office does not come with a magical immunity cloak. It proves that the most potent political brand in the country cannot override the signature of a federal judge. The occupant of the White House, or in this case, the man who desperately wants back in, must still bow to the procedural majesty of the law. He still has to flip the calendar pages. He still has to respect the ink on the subpoena. And here is the psychological hook that drives the nation's collective frustration. Trump has weaponized the narrative that the courts are a deep state swamp, that judges are corrupt operatives, and that the entire justice system is a rigged casino designed to bankrupt him. "Lock her up" wasn't just a slogan. It was a primal scream for weaponized justice against his adversaries. He built rallies around the prosecution of Hillary Clinton. He called for the heads of career bureaucrats. He thundered from every stage that people must face severe consequences for breaking the rules. His electoral pitch was essentially a promise to turn the Justice Department into an iron fist. And now, in a twist of cosmic retribution so perfect it feels scripted by a Greek tragedian, he is the one absorbing the sanctions. He is the one staring down the barrel of a possible jail sentence. He is the one being lectured that his legal defense strategy is so broken that it cannot continue in its current form. The hypocrisy is a monolith. It doesn't just drip, it floods the room. The American people, exhausted by the chaos, are starting to connect the dots. They see a leader who sermonizes about street crime while allegedly committing courtroom malpractice. They see a public servant who demands respect for the thin blue line while shredding the judge's order. They see a messenger of accountability who believes that accountability is a weapon to be used only against others. The tension inside that sealed chamber must have been suffocating. Reports filtering out of the courtroom paint a picture of a visceral eruption. Trump, apparently boiling over with a sense of grievance at being called out, allegedly engaged in an outburst. The sheer audacity of a judge holding him to the standard of a normal litigant triggered a reaction of visible anger. He was agitated. He was furious that the spotlight of guilt was being redirected onto his side of the table. And in a moment that will be replayed in civics textbooks for a century, he was commanded to sit down. He was instructed to control himself and respect the sanctity of the proceedings. The drip feed of information suggests that the threat of physical restraint was introduced into the air of that room if he refused to comply. Just let that visual sink into your mind for a second. We are hovering over the possibility of federal security officials potentially having to physically remove a former president from the room because he would not adhere to the most basic rules of court decorum. We are talking about a situation where the behavioral leash snapped so violently that the judge had to draw a line in the sand with the threat of force. This illustrates how profoundly the situation has deteriorated beyond legalese and into the realm of raw power. It's no longer just about missed deadlines. It's about a fundamental refusal by the president to acknowledge that the robes on the bench carry supremacy over the sound bites of a campaign. It is a public display of conduct that shatters the dignity of the office, and it provokes terrifying constitutional questions. What is the eject button if a president simply decides, "I will not comply"? What is the circuit breaker if he looks at the judicial system and says, "Make me"? These are questions of governmental physics that our founders debated but never fully stress tested to this degree of psychological pressure. We can't look at this in isolation, though. This contempt ruling is a volatile ingredient tossed into a cauldron of already boiling legal catastrophes. This isn't his only dance with a gavel. You have the seismic reverberations of the hush money conviction in New York, where a jury already stamped guilty on his ledger, and the appeals process is churning through the gears. You have a tangled web of immigration enforcement battles, including those infamous plane turnaround incidents where flight paths were altered and legal compliance was questioned, sparking sparking their own contempt discussions. There are the dark, lingering shadows of the classified documents investigations, the sprawling inquiries into the events surrounding January 6th, and a cascade of civil and criminal liabilities that could fill a law library. Now, stack this fresh contempt ruling on top of that mountain of exposure. It's no longer a scatterplot of unrelated problems. It seamlessly paints a portrait of a defendant who views judicial authority as an optional extra. It's a consistent rolling pattern of dodging accountability, defying judges, and utilizing delay tactics that push the patience of the justice system to its absolute fracture point. The American people are the jury in the court of public opinion, and they are watching this wall of resistance. The political fallout is radioactive. Democrats are sharpening their impeachment messaging, arguing that the scaffolding of the republic is being dismantled from within. Republicans are caught in a spiral of anxiety, calculating the midterm math of standing next to a figure who is actively being held in contempt. Legal scholars are firing up their commentaries, declaring that we are sailing into uncharted waters where the compass of precedent no longer works. This is dangerous because it normalizes the idea that a president can simply opt out of the judicial branch. Let's dive deeper into the anatomy of the specific contempt ruling, because this is where the rubber meets the road in proving just how serious this defiance is. The case centers on the handling of evidence in a major federal probe. Judge Merchant, acting as the referee, drew up a playbook for how discovery was to proceed. We are talking about the transfer of terabytes of sensitive materials, the cataloging of facts, and the sacred timeline of procedural fairness. The judge's orders were the load-bearing walls of the case. These are the deadlines, the judge essentially proclaimed. This is the indexing format. This is the chain of custody protocol. You will follow these orders to the letter. There will be no creative lawyering, and there will be no bureaucratic drifting. Compliance is not a negotiation. However, the defense apparatus demonstrated a staggering indifference to these commands. Whether it was a miscalculation of their own ability, a strategy of deliberate friction, or a chaotic disorganization that borders on reckless, the result was a catastrophic failure to comply. And we keep coming back to that number, 9. 9 is not a typo. 9 is not a glitch. 9 is a systematic rebellion. It's a fingerprint of intent. Because in the world of contempt, the legal bar is shockingly simple. You don't need to prove malicious scheming. You just need to prove awareness and violation. The judge holds up the order, confirms the defendant's legal team received it, and notes that the action wasn't taken. That's it. The gavel falls. Whether the defendant finds the order unfair or politically motivated is legally irrelevant noise. If the judge speaks, you move or you fall into contempt. Judge Merchant's finding that these violations were knowing is the legal equivalent of a meteor strike. It means the court believes the defense saw the stop sign and ran it anyway, which completely shifts the power dynamic of the entire case. Judges view the disregard of their orders not just as a personal insult, but as a virus that attacks the immune system of the legal system itself. If a president can simply opt out, then the law is nothing more than a suggestion box. Judges have an arsenal of weapons to enforce their will, and Judge Merchant made it clear he's unlocking the armory. When he called Trump's legal team back into the courtroom, it wasn't for a friendly chat. It was a reckoning. He set the tone by demanding they articulate on the record why the book shouldn't be thrown directly at their heads. The lawyers found themselves in a crucible, trying to spin gold out of the straw of their mistakes. They had to defend the indefensible posture of a client who seems to view the Constitution as a menu. And by all accounts, the judge wasn't buying the spin. He saw the excuses for what they were, thin veils over a strategy of obstruction. The judge's decision to effectively shut down the legal team's current mode of operation is a death sentence for their strategy. He basically delivered an ultimatum: restructure your entire approach, purge the contempt, and prove you can color inside the lines, or the next penalty phase will make your knees buckle. This is where the text of the law meets the reality of a prison cell. Contempt can drain bank accounts through massive daily fines. It can strip lawyers of their credentials, ending careers that took decades to build. And most jarringly for a figure like Trump, it can lead to incarceration. Criminal contempt is a cage. When a pattern of 9 violations is established, a judge's discretion to impose hard time becomes a vivid, looming possibility. The judge can fine him into oblivion, sanction his legal team into irrelevance, or hold him personally in criminal contempt, triggering a constitutional constitutional standoff over whether a Secret Service detail accompanies a person into a federal detention block. The physicality of the moment in the courtroom is what truly haunts me. The visual of Trump losing control while being scolded by authority. The reports suggest an outburst that disrupted the flow of the legal arguments. Perhaps it was a verbal interjection of disbelief, arising from the chair in protest, or an attempt to use the courtroom as a campaign rally platform. Whatever it was, the frequency of authority emanating from the bench overpowered it instantly. The command to sit down wasn't just a request for posture, it was a declaration of dominance. The judge was drawing a boundary line that didn't exist in Trump's psyche. The threat of physical restraint is the last warning before zip ties and bailiffs. It's the judicial equivalent of a parent saying, "Don't make me pull this car over." For a former commander-in-chief to be threatened with physical removal from a room because he can't stop fighting the referee is a level of national embarrassment that transcends politics. It raises the collective blood pressure of the nation because it signals a total breakdown of institutional respect. This behavior echoes across his other trials. The hush money courtroom in New York was a pressure cooker where he constantly tested the boundaries of gag orders, slamming the judge and the process publicly while simmering inside. The immigration lawsuits have been a logistical knife fight, with court orders about turning planes around hanging in the air. Each time a judge peels back the layer of his legal defense, they find a core of resistance that refuses to concede that anyone in any robe has the final say. The political aftershocks are rearranging the tectonic plates underneath Capitol Hill. The moment the contempt became official, the Democratic machine started drafting the narratives of impeachment, framing it as a crisis of legitimacy. Their argument is existential. If a president can be held in contempt 9 times without facing a terminal consequence, the judiciary has been neutered. They see this as the ultimate exhibit in the case against his fitness. Meanwhile, the silence from the Republican camp is deafening, punctuated by moments of panicked backpedaling. They are trying to ride a tiger without getting mauled. They whisper that, of course, everyone must respect judges, but they do so while looking over their shoulder at a base that has been programmed to see rulings as part of a witch hunt. The cognitive dissonance is paralyzing their legislative agenda. Some GOP leaders are dipping their toes in the water of distancing, realizing that burning down the court system might win a primary in a deep red district, but it loses Ohio suburbs and Pennsylvania swing voters. There's a brewing fear that the Law and Order Party is about to be branded as the contempt of court party. For Republican candidates grinding through a tough election cycle, having to answer for the image of a president being told to sit down by a judge is pure political poison. It energizes Democratic voters who want to see a check on executive arrogance, and it absolutely terrifies the suburban moderates who just want normalcy. This isn't a policy debate anymore. It's a character verdict rendered by a federal judge. So, what does the sunrise look like after a ruling like this? The judge has shifted the burden entirely onto Trump's shoulders. The message from the bench was brutally simple. Fix this, or I will fix you. The legal team has to immediately overhaul its compliance mechanism. They have to demonstrate that the reckless, deadline-missing, order-ignoring chapter is closed. If there is a 10th violation, all bets are off. The legal calculus shifts from if to when the hammer drops. A judge who has been pushed this far in the public eye is a judge who cannot afford to back down without eroding their own authority permanently. Criminal contempt proceedings are the next logical escalation. The truly terrifying question that has constitutional scholars burning the midnight oil is the mechanics of jailing a president. The logistics are a nightmare of badges and jurisdictions. The Secret Service is mandated to protect him. Are they mandated to protect him from federal marshals? Do they stand down? Do they step in? Who holds the keys to a cell that contains a former president? Can a president issue a self-pardon for a criminal contempt charge, vaporizing the judiciary's power with a stroke of a pen? These aren't law school hypotheticals anymore. We are watching the machinery of the state try to process a piece of human material that is too large and volatile for the gauge. The system is groaning because it was designed on the assumption of good faith actors and basic decorum. When those assumptions vanish, the thin veneer of civilization peels back to reveal a power struggle between branches of government. The country is living through a real-time lesson in the physics of power, an unstoppable executive ego meeting an immovable judicial order, and the judge, having been embarrassed on the record, has every incentive to ensure that if a constitutional collision happens, it is the the executive branch that shatters against the dock of the courtroom. Zoom out and look at the mosaic of his other cases. This contempt ruling is the red flashing light on the dashboard of his legal vehicle. The New York conviction is already a scarlet letter, and the appeals process is a high-wire act. But when appellate judges look down and see a federal judge in another jurisdiction hammering him for 9 counts of contempt, it poisons the well. It destroys the illusion of a defendant who respects the rules. The classified documents saga is a ticking clock of national security implications, and a defendant who has proven he ignores court orders regarding documents is a prosecutor's dream argument for denying bail or imposing strict restrictions. The January 6th investigations rely on cooperation and the integrity of evidence. A pattern of contempt suggests a fundamental hostility to legal oversight that can be used to draw the darkest of inferences before a jury. Every single time his team steps into a different courtroom, the ghost of Judge Merchant's gavel will be sitting on the prosecutor's table. It damages his credibility to zero. It signals to every other judge in America that this is a party willing to drag the court into the mud and ignore the rule book. As a result, the latitude typically afforded to powerful defendants shrinks to nothing. Judges become less tolerant, stricter on deadlines, and far more likely to impose punitive measures for the slightest misstep. The legal system operates on a gradient of trust, and Trump's account is deeply overdrawn. This is the crucible moment for the rule of law in America. The rule of law is a fragile ecosystem. It's the belief that a piece of paper signed by a judge can stop the most powerful armies and the richest men. It's the invisible wall that protects the citizen from the tyrant. When a president shatters that wall by violating orders 9 times, he's not just breaking a rule, he's inviting anarchy. And the judges, the gatekeepers of that wall, are now roaring back. They are saying, with the threat of iron bars, that the game is over. This isn't about political disagreements over tax rates or foreign policy. This is about whether the words on a court order have any meaning. Judges are holding this man accountable because if they don't, they might as well mail their robes back and let the country slide into authoritarianism. The courage it takes for a federal judge to stare down the man who might be the next president and say, "You are in contempt," is enormous, and it signals that the judicial branch is preparing to bleed to defend its authority. This is a crucial pivot point. The system is collecting on its debts. The patience of the courts has evaporated. The next chapter is being written right now, and if the pattern of defiance continues, we are heading toward a scene that no screenwriter could invent: a Secret Service motorcade pulling up not to a rally, but to a federal penitentiary. This is the line in the sand. The rule of law is either real or it's a fiction we tell ourselves. Right now, the judges are telling us it's very real, and they have the cell keys to prove it. So stay locked in, because this roller coaster has just hit the apex, and the plunge downward is going to rewrite everything we know about power in America.